Well, thank you all for coming today. My name is Judy Williams. I've been practicing law here in Billings since 1985. I started out practicing law at Montana Legal Services, where I mostly did family law and custody actions and that sort of thing. So this has been a major part of my practice of law since I first got out of law school. And the reason you're here at this class today is because you have indicated that you have a family law problem, and you're either working with Montana Legal Services Family Law Project or with the Self-Help Law Center. The purpose of the class is to give you general information about family law, and we divide this into two parts. The first part, I'll talk about divorce generally, and then we'll take a short break, and then I'll talk about parenting plans, or what you might know as child custody, in a second part. While I'm presenting this, I'll try to cover everything. If you have any specific questions, please make a note of them, and we will go over those at the end. The first thing that I usually talk about when we are talking about divorce is how a marriage is formed. Since in Montana there are a couple different ways to get married, sometimes I have clients who actually have a question about whether or not they are married and whether they need a divorce. So in Montana there are a couple different ways to get married. The kind you're most familiar with is a ceremonial marriage, where you go to the courthouse and get a marriage license, and then you're married by a minister or a judge or someone else who's authorized to do weddings. The second most common type of marriage in Montana is common law marriage. And in order to form a common law marriage, where you don't have a license or an official ceremony necessarily, is when two people, has to be a man and a woman in Montana, we do not have same-sex marriage in Montana, decide at a certain point on time, what we call a date certain, that from now on they are married. And from then on they hold themselves out to the community in general as husband and wife. That's an important element, is the public part of a common law marriage. It's really not possible to have a secret common law marriage, because the holding yourselves out as husband and wife is an essential element. Common law marriage is not living with somebody for a certain number of years and ending up sort of accidentally in a common law marriage. It's not checking into a motel saying that you're Mr. and Mrs. when you aren't really. You can't, as they say, get accidentally married by common law. They told us in law school that it can't creep upon you unawares. You have to make a decision to be married and go forward from there. If you have a question about that, you should talk to someone, a lawyer, about that, or someone who is an expert in determining whether or not you have a common law marriage. If you have a marriage and you don't want to be married anymore, you have to terminate it. In Montana, we call that a dissolution of marriage. The state views marriage as a contract, and if you're not going to be married anymore, you have to end the contract, and the state requires you to do that formally. If your marriage was by common law, you still have to get a formal divorce. There is no common law divorce. There's, as you might imagine, more than one way to end your marriage. One way is called an invalidity of marriage. Most people know that as an annulment. Annulments are fairly rare, and you have to meet specific criteria in order to get an annulment. The most common criteria that people meet are a lack of capacity. For instance, a person has a mental disability that makes them unable to form a marriage, or they entered into the marriage under fraud, that someone misled them about important elements of their relationship or their marriage, so that the marriage should be declared invalid. Or age is another issue. If you're under 16 in Montana, you can't enter a valid marriage at all. And if you're 16 or 17, you have to have a parent's permission to be married. If that is missing, then you cannot form a valid marriage, and your marriage could be declared invalid or annulled. The final most common basis for invalid marriage is that it's a prohibited marriage. That means that one of the people is still married to someone else, so that they call that bigamy in criminal law, but we call that a prohibited marriage in civil law. Or certain degrees of relatives are not allowed to marry legally in Montana. As you might imagine, first cousins, your uncles, your fathers, those kinds of, or your mothers or your aunts, you're not allowed to marry people of a certain close relationship. That's pretty rare because there aren't that many people who would meet those specific criteria. The second way that people sometimes are interested in ending their marriage is by legal separation. When I talk about dissolution of marriage, those elements all have to be present in order to get a legal separation. You have to do all the same things as though you were getting divorced. Most people are interested in a legal separation for religious reasons, that their religion prohibits divorces or in some extreme cases even excommunicates people who get divorces. Those people are often interested in a legal separation. The only difference between the legal separation and the divorce is at the end of the whole proceeding, you just get a document that's called a legal separation instead of a dissolution of marriage. The danger of the legal separation is that you are still liable for your spouse's necessary debts, like medical expenses and those sorts of things. So that's a big negative, in my opinion, for a legal separation, because you're not off the hook for necessary debts. The other thing is that even if you get a legal separation, if you change your mind and would like it to be a divorce, after 180 days or 6 months, either party can ask to have it changed to a divorce. Now this presumes that all through the proceeding you've both agreed that you will just get a legal separation. You could ask for a legal separation, but if your spouse says no, they want a divorce, it will be a divorce, whether you wanted it or not. And that leads me to divorce, which does end your marriage. And a divorce is the legal proceeding that decides all of the important things about what happens to the things you acquired during your marriage, to your children if you have children, and also what happens to your debts. There's even more than one way to get divorced in Montana. The adversarial proceeding I'll talk about more in a minute, but one unusual way we have in Montana is called a summary dissolution. And if you meet certain specific criteria, then you can get a divorce using forms that are provided by the state. And it's, while not completely simple, it's easier for you to do that kind of a divorce on your own. But there are specific elements that you have to be able to show in order to be eligible for a summary dissolution. First of all, the husband and wife both have to agree that they want to get a divorce, and they have to sign all the papers together. That can be a hurdle in many cases. So that's the first thing. You have to be cooperative and know where each other are and agree on everything. You have to either have no children of your marriage or have an agreed upon parenting plan for your children, and you have to have child support established. You can't own any real property. Real property is land or a home. It does not include things like your cars or that kind of thing. It's only land or houses. You can't have any unpaid, unsecured debts. Those would be things like credit cards that are bigger than $8,000 total. You can't, all of your assets except cars that you have a loan on that's secured by a bank loan, so those would not be unsecured debts. Those are called secure debts because the bank, if you don't make your payments, the bank has the right to come and take the car back. All of your assets other than those kinds of things cannot be worth more than $25,000. You have to agree on the division of your property and your bills. Neither of you can ask for maintenance or alimony, and you have to agree that your case will not be appealed to the Montana Supreme Court. So it has to be totally amicable. I often joke that if people can get along this well, they probably don't need to get divorced anyway, but there are quite a few people that actually can meet these criteria and end their marriages that way. I'm going to talk more about the other kinds of divorce in a minute. something that I sometimes hear from people is that they want to use the Montana Reconciliation Act, which is a method that's in the statutes that's supposed to help the people, the husband and wife, stay together. But in Montana, the elements of the Reconciliation Act have not been funded, and so there really is no mechanism to invoke that. So if your spouse is saying, well, I'm going to try to make you go through the Reconciliation Act requirements, you can ignore that because it's not going to happen. In order to get a divorce in Montana without using the summary process, you need to meet a number of criteria. In both processes, you have to be a resident of Montana, and you have to have lived here for at least 90 days before you start your divorce action. If you haven't been here 90 days yet, you have to wait until then. The parties to a divorce are the petitioner and the respondent. The petitioner is the person that starts the action, and the respondent is the person who will answer to the action. The grounds for marriage in Montana is a no-fault state. You simply say that your marriage is irretrievably broken with no chance of reconciliation, or that you've lived apart from your spouse for at least 180 days, 6 months. I can always tell when I'm seeing clients for divorce that have been watching television because they'll say, talk to me about things like adultery or mental cruelty or abandonment and things like that, because in other states, you have to meet criteria like that in order to ask for a divorce. In Montana, basically, you just say you want a divorce and you can get one. I also often hear from clients who say, well, my husband or wife won't give me a divorce. And I respond, divorce is not a gift. They don't get to stop you from getting a divorce. If you want a divorce, you get a divorce in Montana. You just have to say you want one, and nobody can stop you from being divorced. They can make the action take longer. They can put roadblocks in your way and make it a miserable proceeding, but they can't stop it from happening. There's a lot of paperwork involved in a divorce. If any of you have seen the summary dissolution packets or other paperwork, you're aware of that already. So I'm going to start telling you about all those papers that you have to get through in order to start and finish a divorce action. The first thing is called the petition. The petitioner files a petition, and the petition sets forth how you want your divorce to be handled, how you want your property to be divided, who should pay which bills. If you have kids, it'll include a parenting plan that sorts out what will happen with the kids. The response is the paper that the other party can file if they want to. One person starts the action and says, here's how I think it should go. The other party has a chance to say, yes, I agree, or no, I don't agree. That's their response. It doesn't really make any difference to the court who is the petitioner and who is the respondent. There's no advantage to being the petitioner or respondent necessarily. Some people worry that if somebody else, if their husband or wife petitions for the divorce, that the court is going to see their side of the story first and be biased in their favor. But at the courthouse, the judges don't even know the petition is filed. It gets filed in an office and put in the file cabinet, and nobody even knows it exists until something happens to bring it in front of the court. So it's not as though the judges are sitting around at their leisure going through the files. They're busy enough with the hundreds and hundreds of actions that are in our court every day that they don't take any interest in your case until somebody makes them. Once the response is filed, the other document that both parties are supposed to prepare are the declaration of disclosures. And those declarations are meant for each party to tell the other what all of their assets or property are, what their debts are, what their income is, what their expenses are. All of those things are supposed to be disclosed to each other. There aren't supposed to be any secrets. Nobody's supposed to have a secret bank account or a secret stash of stocks and bonds or hide their grandmother's jewelry or something like that that they inherited. It's all supposed to be open. The petitioner has to file their declarations either at the same time they file their petition or within a certain number of days. The respondent also has a certain number of days to produce their declaration of disclosure. When you are, I'll talk a little bit more about those in a minute, but the thing to remember about the declarations is to be open and honest and tell everything, not to try to hide anything. Because if you do have something valuable, say an antique you inherited or a piece of jewelry that's sentimental to you that was inherited from a relative or a gift, disclosing it doesn't mean the other party is going to get it. It just needs to be out there as something that exists. There are penalties for failure to disclose that kind of go up in escalation but can result in losing the asset for failure to tell about it. So you don't want to have that happen and end up losing something you care about just because you didn't write it down. So keep that in mind. Also, your disclosures in terms of your assets and your property need to be fairly general. You don't need to count your silverware. You don't need to count how many shirts you have. You just need to put something like kitchen utensils and give what would be approximately a garage sale value. If you have something valuable, again, disclose it, but don't torture yourself by inventorying every single thing in your house. You do need to be pretty specific with your debts, and especially when you're dividing those, you want to make sure they're all out there and are divided up. And with your income and expenses, again, be accurate, don't hide anything, but you can be fairly general. You don't have to list every haircut that your kids might need. You can put a general category for things like that. Once you have prepared your petition, you need to notify the other party that you're asking for a divorce if you're not doing a summary dissolution. We call that service. You're serving the other party with notice that you're asking for a divorce and filing this petition. With the service documents goes a summons that basically invites the people to court. It's one of those, state of Montana sends greetings to you. Guess what? You're